Thank you, Madam Chair. My name is Ed Heiselmeyer. I am a senior research fellow in health policy studies at the Heritage Foundation. Thank you for inviting me to testify today. Views expressed are my own, not those of any institution or any attempt at representing a position. I have prepared testimony, written testimony to the benefit of the committee, so I will not read that. I will simply summarize that briefly. My analysis is of the effects of the Medicaid expansion, and I draw the committee's attention to the fact that this is a significantly different population than what one thinks of traditionally in Medicaid. Traditionally in Medicaid, you're talking about vulnerable populations who really have little or no control over their circumstances, or children, the elderly, the disabled, etc. This population, however, consists of able-bodied adults who actually do have considerable control over their own circumstances. And so the question is this the right approach to providing coverage to this population? I don't think it is, for several reasons. One of the points is simply that, and I think really the largest point, is the reason that this population has low incomes is simply that they have low workforce participation. Again, unlike children or the elderly or the disabled who may have some, who by their very nature can't fully or at all participate in the workforce. This is a population that is capable of participating in the workforce, but is not, or not sufficiently to have incomes above 138% of the poverty line. And that raises some interesting questions as to why. But when you investigate why, it's pretty apparent that this is a population that there are a number of reasons for them not working. One might be that they're in school. That's not unreasonable. Another might be that the economic opportunities where they live are quite limited. They're looking for a job and they can't find one. Another might be that they have some behavioral problems that make holding a job difficult. And another might be that they're poorly motivated. Whatever it is, the principal issue with this group is the lack of hours worked. If they were working, just as a reference point, a full-time federal minimum wage job, $7.25 an hour, they would be at 130% of the poverty level. Now, what that means relative to the Medicaid expansion is that if you expand Medicaid, you will be including those people. But if you were to not expand Medicaid, they would be able to get coverage elsewhere from an employer or through the new federal subsidies on the exchange. The reverse of this is also true, and that is the concern that I have in particular for this group, and I've discussed and provided data in the paper, and that is that by adopting the Medicaid expansion, particularly since half of this population are young adults between 19 and 34, you would in effect create a system whereby not only would they have an incentive to limit the hours and income they work to stay on Medicaid, but most importantly and uniquely, their employers would be fined if they made too much money. Now, we are well aware in means-tested assistance programs that there is an incentive on the individual receiving assistance to keep their income below the level that qualifies them. But we have no other previous examples of a situation where if the individual's income exceeds the threshold, not only would the individual lose the benefits, but their employer would be fined as well. That is a tremendous disincentive to upward economic mobility and creates economic stagnation. I think particularly focusing that on younger adults has an overwhelmingly disadvantageous result. Interestingly enough, this morning, the Congressional Budget Office released its 10-year estimates. And in there, one of the things that you may have seen in the news story is it estimates that the effects of the Patient Protection and Affordable Care Act in total, of which the Medicaid expansion is part, will reduce the total number of hours worked on net by about 1.5% to 2% through the period from 2017 to 2024 entirely because workers will choose to supply less labor given the new taxes and other incentives they will face and the financial benefits some will receive. And that's from the report. So I think we should be very concerned about essentially taking an able-bodied and younger population of adults, 3/4 of whom roughly do not even have dependent children, and putting them in a situation where not only are we rewarding less work activity, but we're actually penalizing more work activity. Now, that said, on the Medicaid expansion, I've gone into more detail in the testimony. I'll be happy to answer questions later. Let me turn to address the question that you started with here, and I was listening, and that is how the law operates, because there seems to be some confusion. So let me review the basics. As Director Allison and Ms. Burgess and others have pointed out, the waiver is subordinate to the state plan. That's true. So if a state were, for example, if the state were to increase eligibility in an area where it may optionally do so and then provide that coverage through a waiver, and then the state would roll back that eligibility, then yes, the waiver would largely become moot. The problem with this, in this circumstance, is not clear. In fact, it can be quite strongly argued the opposite, that this is not optional for the state. To understand that, you have to review the history and the law. When the legislation was written, it was written into the section of the code, and I can give you the citation if you'd like, that clearly spells out that for a state to receive any Medicaid funds, it must do the following. And the expansion to this population was added to the end of that section, where it remains today. The next section of the code says that a state, at its option, may do the following in terms of covering optional populations. So as a matter of fact and law, the expansion that was enacted in the PACA was enacted into the mandatory section of the Medicaid Code and remains there. And that's the next point. The Supreme Court did not strike the statute. The Supreme Court did not amend the statute. Congress has not subsequently amended the statute. The statute, as it reads, says this is a mandatory section. This is a mandatory requirement. What the Supreme Court did is to say that before you agree to adopt this, the state has to be given a chance to say yes or no. And so the interpretation, and this includes folks who litigated this case, is that were a state to adopt the expansion, as Arkansas has, and then file a state plan amendment to reverse that decision, that subsequent decision could be challenged on the grounds that this was a one-way upgrade. You can't go back. And the Supreme Court, in the considered opinion of some people who actually litigated the case, their view is when it got to the Supreme Court, such a case, the court would probably say, yes, that's why we gave you the option to not go in the first place. Now, we don't know that for a fact. That hasn't been tested. But what we do know for a fact is the statute has not changed. And so the opinion of the U.S. Department of Health and Human Services, and there was a question as to whether this is in regulation, and no, interestingly enough, they have never put this in regulation. The opinion of the U.S. Department of Health and Human Services that Arkansas or any other state adopting the Medicaid expansion may subsequently reverse it, and if this is treated as an optional population, is in no way, shape, or form either binding or even necessarily correct. How could we find out? Well, the answer is quite simple. A state that has adopted the expansion subsequently drops the expansion on the assurances that they can do it, At that point, anyone who was previously covered as part of the expansion would have standing in federal court to sue to force the state to retain the expansion. And that would again have to be adjudicated by federal court, interpreting what exactly the Supreme Court meant when it didn't change the statute, didn't strike the statute, but simply gave the states an opportunity to voluntarily choose whether to adopt that or not. That could be a very long process. But I just wanted to clarify that because that is an area of considerable concern.
Right.
Thank you, Madam Chairman. I'd be happy to answer questions.
Thank you.